clearly and reasonably slowly. You have the floor. Good afternoon, dear colleagues, esteemed journalists. We have one of the events which is kind of rare events. The briefing is provided by the rank and file judges. Nobody actually occupies any kind of administrative or the public service position. So we would like to demonstrate another aspect of our work. Not so often they talk about the judicial reform or the problems we face today and the circumstances under which the judicial system tries to survive. That's why I invited here different people from different regions who represent different jurisdictions to give you a chance to listen to them, to put them these questions, and to form maybe the image of the realistic judge who on a daily basis take care of his not very easy work under very difficult conditions. I would like to introduce our participants in our briefing. Mr. Oleksandr Sasevych, Judge of the District Administrative Court of Lviv, member of the Board of Judges of Ukraine. Tetyana Suyarko, Judge of the Economic Court of Kharkiv region. Denis Kovalenko, Judge of the Rubizhansk District of Lugansk region. Kotormus, Judge of the Konstyantynivka District Court of Donetsk region, and Lyudmyla Volkova, Judge of the District Administrative Court of Kharkiv. I'm going to be moderator. My name is Volodymyr Kravchuk. I'm Judge of the District Administrative Court of Lviv, member of the Constitutional Committee. We are going to start this briefing with the problems of judicial communication. So the floor is given to Mr. Oleksandr Sasevych. Thank you. Esteemed colleagues, the topic, the issue which was voiced by our moderator is really very topical and very complex. Why so? The Revolution Dignity actually opened our eyes, including the representatives of the judicial branch of power. I'm talking about the problem of the absence of any kind of informative policy in the activities of one of the branches of the authority. That was really a problem, and we came to understand that after the Revolution Dignity, the judicial core courts, which includes not only our colleagues, the names of who you can hear from TV screens. We are talking about 9,000 people who work decently and who to who our society do not have any claims. We understand there is a problem. There is a lot of work, routine work, but to show the fruit of the results of the work which we did, unfortunately we cannot do that. That's why the 12th extra regular Congress, which we had last year, one of the things we were discussing that we had to develop information policy, in making deeper and more extended communication. It's no secret that this branch of authority didn't have, so to say, its mouthpiece. Maybe some time ago they failed to pay attention to this specific issue, but the time is flying and the information, and you are included like the sharks of the pen of mass media. You actually would like to give some information, but let me remind you that 1 year ago, any issue, please, no comments. They would say you can actually acquaint yourselves with the ruling and all the information is contained there. We today, the judicial power, judicial branch, we actually declare that we become now open, and we call all our colleagues judges to join us. Today, you know that the Council of Judges has passed a decision to set up the institute of the speakers in the judicial branch of power, and what we understand, the judge speaker, this is in some extent it is interpreter from the judicial language to the normal, so to say, normal people language. So I say the journalists are the conductors of information. They are our colleagues. They are like we. They are also interested in the end product to provide some information to their audience. Journalists to their audience, and we have to provide this information to the citizens, and it's a win-win situation. For the judges, if he is talking to create truth, to build up the confidence and trust, and me, and the same about journals. If I can provide the information which is going to be understood by the journals, that means that the end users of this information our audience will understand that. The same, if you're talking about the Institute of Speakers, we rely upon that institute or institution very much, and we expect that during the first period of time, they will be able to raise our rating in the realm of information. Number two, we set up the press center of the judicial branch, and actually the results of their work that was informing journalists regarding providing information regarding the criminal cases associated with the Maidan situation. We actually inspired them to do that. I believe they have already amassed some experience, and we continue to work along those lines. And the work on judicial work on the websites, related. Any citizens who would like to address the court, where he would like to find the information on the website about this or another court or judicial information. Actually, we are working on the methodology of situation, information, content of those websites. And summing up my very short speech, I would like to say the following. We are all for openness. We are for the situation when the citizens of Ukraine know the truth, and we can reach the truth only through communication with the civil society, while the journalists, you are our conductors of our information, and very much depends on your professionalism, unbiased nature, and the balance of interests in the information. Very much on this depend whether our citizens will get the real and objective, unbiased product, which is really at the core of our activities. Thank you, Mr. Sasevych. Just I would like to add a few words that one of the problems of judicial reform and any kind of, let's say, if we are talking about the information provided about the court activities, this kind of one-sided information. Very often there were some problems for the journalists to get the information directly from the first hand, so to say. But everything is subject to changes, and as they say, there are judges, speakers, who along their lines of duty have to provide such information. Each court now has press service, sometimes press service or press secretary, but there are people who are responsible for such communications, and of course we would like to provide such possibilities for the journalists to be able to actually to have this source of information at the time, and when they have the possibility to receive that information, then the information directly from the courts or the judges. Last year we paid attention to that issue, tried to resolve that, but even today we can see situations when we are talking about something directly related to the judges. The information is provided without their invitation or their involvement. They involve some kind of allegedly experts, but very often they are not experts at all in these specific issues. So while calling upon all of us to respect the truth, I do hope that journalists, not only journalists, anybody who is writing or talking about the events taking place in the court will try to get the real information. If you have any problems with obtaining this information, please inform us. we are just at the beginning of the road. Not, of course, not all the judges will support this kind of direction development of judicial power, but we are going to provide the rapid response to your problems. And this issue is very sensitive, very important from the point of view of the judicial power, and we can observe that not only based on the examples of our communication, but also if we're talking about the analysis of some statistics, ratings, and that's why I would like to give the floor at this point of time to Tetyana Suyarko, Judge of the Economic Court of Kharkiv region. You have the floor, Tetyana.
I would like to present you some data from a sociological survey, and this data which you can hear quite often in the mass media related to the trust to court system. This should be called nothing else as manipulation. Sometimes you can hear that the trust to courts is not more than 4% among population, but when such surveys are carried out among those who directly dealt with the court system, with judiciary system, shows much higher figures. For example, the survey data, which was held among those who directly appealed to courts, shows that the level of trust to courts immediately raised up to 56%. Some other studies show the figure of 40%, speaking at the level of trust to courts. In general, the split in data shown by different sociological surveys is quite big, and much here depends on who led the survey, how respondents were selected, how the how the question was formulated, etc. By the way, we can say, looking at the data shown by those surveys, we generally can come to a conclusion that among those people who appeal to courts, the level of trust is around 56%, while among that 58% of Ukrainian population who never dealt with the court system, the level of trust is around 14%, and I believe that this is this somehow reflects the specificity of the court system. And the specificity of court proceedings is that there is the winning party, there is a losing party, and that is 50% of those who go out from a court, they feel unhappy with the court or the court practice. That's why we should clearly understand that there should be half of people who dealt with courts who definitely may not be satisfied. On the other hand, quite often people answering questions do not distinguish between their beliefs and between their real vision of the situation. By the way, the sociologists suggest that trust to church in our society is not higher than 65%. That's why when we quite often speak about raising trust to courts or strengthening trust to courts, strengthening confidence in courts, we should better speak that we need to raise effectiveness and efficiency of judiciary. And with this, I would like to give the floor to Mr. Kravchuk. Here, I would like to give the floor to Oleksandr. So, by the way, the court procedure requires that the judge should ask whether you trust this court. And by the way, 83% of respondents present in proceedings, they answered yes, we trust. There is one more specificity of court system and courts. The specificity is that those people who dealt with the court system directly, they have 4 times higher trust to courts than those who never approach to courts. Trying to understand this phenomenon, we came to conclusion that our society imposes artificial prejudice to courts among people, stating that the courts are suspicious institutions to which people should not trust. This again suggests that this strange attitude is a result of massive manipulation with social perception, and unless everybody become very conscious about these manipulations, all people would be vulnerable to these manipulations, and we will observe the same results of surveys among people. We quite much discussed the reform of judiciary. We have been discussing this for quite a number of years. I do not wish to discuss this judiciary reform today. Today, we would like to point out some very specific problems which are essential for the court system functioning. We would like to share these problems with those people who are not aware about the problems. And with this, I would like to give the floor to Volkova, Lyudmyla, and request Lyudmyla to express her vision of the long-term delays in election of judges. When we as ordinary citizens go to court, we wish to get support in enjoyment of our rights. And in this context, we wish to have unprejudiced, unbiased court without any political influence, able to make fair judgment. And by the way, the previous term of many judges, for which the for which the judges were elected. And as of today, in the Supreme Court, there is 500 files, personal files of those judges whose term in office has expired, and they are not reconfirmed. For example, and the same situation is in all the oblasts. In the Lochev district court, they have just one judge. In Kharkiv, they have 9 judges who are able to work as judges, while there were no vacancies. The rest of judges in Kharkiv district, in one of Kharkiv district courts, cannot act as judges. And by the way, this creates an extreme load for those judges who remain in office, and this brightly shows that judges cannot be absolutely independent from those who appoint them. And many foreign bodies like Venice Commission and European associations of judges many times point out that the offices of judges should be extended unless this judge had received any sanctions in result of violation. And they pointed out that appointment of judges and confirmation of the appointment of judges should be based on clear criteria, transparent criteria applied to the previous work of these judges. And what is most important is to isolate the judges from political discretion. Only under these circumstances, the judges won't take into consideration opinion of those who appoint them when they make fair judgments in court. Thank you.
Just to echo what has been said, I would like to draw your attention that both the Judicial Congress and the Council of Judges for 3 times, and the Supreme Court, and the Higher Administrative Court, and the teams and collectives and groups of the judges repeatedly addressed the Verkhovna Rada, the Parliament of Ukraine, the Committee for the Legal Policy and Justice, with the request to resolve the issues of the early election. Unfortunately, we have a different procedure for electing the judges. Despite the fact that one of the tasks of this reform is depoliticization of the nomination process, sometimes we have an impression that the Verkhovna Rada intentionally actually is provide this delay in order to avoid the necessity of the early election of the judges and to resolve this problem from the political point of view. Sometimes we can hear the statements which have nothing to do with the political principles regarding the, let's say, the impossibility to elect the judges for some political, non-legal grounds without actually specifying any kind of the personal claims or whatever, just because there are some social interests in cleaning and renovation. In our opinion, this is not a proper method to be used, and there are so many courts approach us with the collective addresses, and they also voice their concerns about this kind of judicial reform manner And we hope that the issue of discrimination or non-discrimination, justice or injustice, actually is far beyond the framework of the legal environment, the legal framework. Nobody should stay away the issues dealing with justice or ensuring justice. It's very surprising that we can hear those judges who are actually accused of some kind of unjust or the rulings, but the responsibility is individual, and any kind of collective responsibility are absolutely inadmissible. We do not have the right to repeat any kind of genocides. Speaking about the judges, somebody can coin another term as the justice side, and we are talking about some individual responsibility, the qualification or skills assessment, the individual approach to each judges. We do believe that all that will be regarded as the grounds for the specific enactment, and we again address the Verkhovna Rada to immediately resolve the issue of the earlier election of the judges. Otherwise, we are going to meet with the paralysis of the judicial system in Ukraine. And we are not talking about the fates of some judges. We are talking about the further destinies of those numerous cases in which the perpetrators cannot be brought to criminal responsibility because the term of the responsibility expires someday. There are, in Ukraine, at least there are 5 courts where none of the judges has any authority. 5. That means that hundreds upon hundreds of thousands of people are deprived of the right to have access to the court or to justice. Unfortunately, our judicial system cannot on its own resolve this problem, and those 547 judges who await the election, they cannot become the hostages of different political interests. Only depoliticization of this procedure, of this process, can actually return at least 10% of the judges back to the composition to the judicial court for them to decently and objectively take care of their duties. Otherwise, this boils down to some claims, to complaints against the courts, although the courts or the judges do not have any lever to exercise some kind of influence on the authorities. And we call upon everybody, the journalists, to raise this issue. This is not only the issue which pertains to the judicial power. We are talking about the right of the citizens to have an access to judicial power. Again, I would like to draw attention to the problems of providing justice in the ATO zone. And I would like to turn the mic to Mr. Kotormus, the judge of Konstyantynivka District Court of Donetsk region. Thank you. I would like to say that the biggest problem in our country today is the war which is waged in the eastern parts of our country. The court is no exception here. It also has been affected by this problem. If I'm not mistaken, 12% of the territory of Ukraine is now temporarily occupied. I'm talking about the Crimea and partially territory of the Lugansk and Donetsk regions. This territory actually doesn't have any chance to have an access to Ukrainian justice. And this, unfortunately, the citizens are deprived of this right. I mean, those who remain there. And the judges who used to work on that territory, they face a very big problem. What kind of problem I'm talking about? This problem is as follows. After the well-known to all of us circumstances or development of the situation in the eastern parts of Ukraine, some of the patriotic judges, they decided to work in Ukraine, whatever happens, and to remain loyal to the oath they took, the oath to their country and the people of Ukraine. And that's why they voiced their desire, their wish to be actually moved to some other courts on the territory of Ukraine. But unfortunately, we have the situation, this is not enough. Unfortunately, the process of moving those judges to different parts of Ukraine is too long, too lengthy, too painful. And despite the fact that those events have been in place for more than let's say 18 months now, and there is a number of the judges in Ukraine who just do not have a chance to be moved to another court or other courts. And actually, this possibility just blocked. They were temporarily registered with certain courts, which allow them to receive some judiciary fees. But in September this year, this term expired, and unfortunately, they are deprived of the possibility to get this kind of pecuniary remuneration. And I would like to say the following: not only the judges come from this territory who actually deserve our attention. There are some other problems. There are still judges who remain in those territories, and those judges, being citizens of Ukraine, they, in my opinion, they became the traitors. They betrayed. They did not fulfill their oaths, and they started to serve even the terrorist organization. But whatever, it's real paradoxical, but those judges remain to be Ukrainian judges. They have not been fired. They have not been brought to any kind of responsibility. They have been and still are judges of Ukraine. It is really amazing, and I really believe this situation very much surprising. Seemingly, we could resolve this problem in a very easy way. We could deprive those judges to remain judges, and actually take their vacancies and use them in the other parts of Ukraine, other territory of Ukraine, give the chance to other judges who remain loyal to Ukrainian people to take those positions, or and I believe that the meeting of the judges, which we are going to hold in the near future, they will not forget this problem, that all the authorities within their competences and jurisdiction will do their utmost to protect those judges who, in my opinion, are, without an exaggeration, real heroes. Without coming into details, many people just risk their lives trying to get from that temporary occupied territory to the government-controlled territory of Ukraine. Many of them actually remained without their housing, etc., etc. So I would like to address everybody, and just not to forget to remember about those people and do your best in order to help them to remain and feel themselves Ukrainian judges, citizens of Ukraine. And I still hope that the competent bodies, agencies will keep it in mind and do something about that. Thank you.
Thank you. The ATO problem quite seldom is covered from the judge perspective. Of course, the war or warfare is not the case, the pretext to involve judges, but nevertheless, in the war times, our those 300 judges out of 8,000 which we have in Ukraine, their hardships deserve for our attention, and we should find a way to provide them with the judge fees, salaries, and to appoint them into vacancies. Now, I would like to bring to your attention the issue of those judges who are appointed for the first 5-year term. In line with the Constitution, this is the President who appoints the judges for the first term, and after the first term, the time appointment of judges should be approved by Verkhovna Rada. And again, here we have many judges whose first 5-year term has expired and who are not reappointed by Verkhovna Rada. Thank you for this opportunity to bring to the attention of Ukrainian people that in the majority the judges quite positively assess and see the draft amendments to the Constitution, which was approved by the Constitutional Commission, and they approved many suggested changes. This is for the first time in the history of independent Ukraine when trying to find solutions to the judiciary reform and to the reform in judges' career and trying to change the general approach to the judiciary. The experts were involved, high-quality experts were involved, and professional community at large was consulted. They had an opportunity to express their vision, and by the way, many recommendations which the judiciary community provided were taken into consideration. In particular, when the draft amendments to the Constitution in judiciary area were ready, this part of amendments was forwarded to the Venice Commission. The Venice Commission is a high respected body in Europe. This commission has a big authority and actually the entire European family is very attentive to the recommendations and opinion of the Venice Commission. The Venice Commission produced its opinion, and this opinion was taken into account by Ukrainian party. Additionally, some recommendations were provided by the Committee of Ministers of the Council of Europe. They recommended some details as to the structure of the judiciary and as to the selection of judges. And then here we would like to look at one more specific problem, which was omitted, which was omitted in course of drafting constitutional amendments. Somehow it was left. It was put aside by the members of the Constitutional Commission. They simply did not devote enough attention to those judges who currently are ongoing probation period, that is, who are appointed for the judge position for the first 5-year term. Also, attention should be given to those judges who already were appointed for lifelong period of office, and those who were appointed for the first 5-year period. Actually, the approach to all these categories was different. Those who are already appointed for the lifelong term, the Constitutional Commission suggested to remain them in office up to the moment which is foreseen by the Constitution. But as to those judges who were appointed for the first 5 years, 5-year term, the proposal of draft amendments suggests that they should carry out their responsibilities only up to the end of their 5-year term. We believe that this is the fact of discrimination. This is discrimination because based on the time of appointment. Of course, this discriminative approach cannot be tolerated. Both Venice Commission and Committee of the Ministers of the Council of Europe provided several recommendations that saying that appointment to lifelong term for those judges who have successfully passed first 5-year period should be automatic unless those judges who made some violations, either criminal or administrative violations in course of their first 5-year period, their term in office should be terminated. Also, I would like to point out that the issue which I described now was discussed by the Advisory Council of European Judges. This is the body which is established under the auspice of the European Union. This body is authorized to to make an opinion upon request from any institute under the European Union, under European Commission. And on October 16 this year, in Strasbourg, this advisory board had its session, and in its opinion number 18, they stated that they produced opinion about similar problem. Currently, I have handy unofficial translation of this opinion. And since we received this opinion from one of the members of this body, I I believe that for the official translation will be close to what I have. The decisions which destroy the guarantees of independence of judiciary should be unacceptable. For example, parliamentary majority and the government cannot decide on the powers and the term of those judges who were appointed legally and lawfully, and unless there was a special judgment made as to specific judge.
This is what pertains directly to the position or the stance of those institutions which our today's authorities heeds to. And we can see that indeed the draft constitution of Ukraine, which was adopted or approved by the Constitution Commission as a whole, takes into consideration almost all the proposals on the part of the Venetian Committee and the Council of Europe. And unfortunately, what I mentioned a few minutes ago did not become the subject of even discussion during the latest session or meeting. And we believe that this is because, indeed, there were some other also important issues related to our judicial system, its build-up. However, since the President of Ukraine is a subject of legislative initiative, and we understand that he, as this subject, has an opportunity and a chance to remove or to, let's say, to resolve this problem. The judges approached the President of Ukraine with their letter, and now taking this opportunity to inform the mass media about that. We would like to address the President of Ukraine on the subject of legislative initiative to cancel this kind of discrimination which is already being fixed in that draft. What is our proposal? The Venetian Commission, in one of their conclusions, already considered the proposals of the Ukrainian authorities regarding nomination or appointment of the judges who were selected not for good. And then it was proposed that, okay, when the amendments to the Constitution become effective, those judges who were appointed for the first time to their positions should be regarded automatically as those who are elected for their lifetime as judges. And since the National Committee did not come with any kind of remarks or comments on this specific proposal, we propose as a possible alternative or option to change, to amend the item related to the transitional provisions, which actually means the termination of the authorities of those judges who were initially appointed to their positions, and which is related to those judges who were for the first time appointed as judges. And we can see and we support the proposed procedure of assessment or evaluation of each of the judges. And if the President of Ukraine passes the decision to approve this proposal, the members of the Constitution Committee, by the members of the Constitution Committee, we believe that this would meet the European recommendations which I mentioned before. Also, it would be very fair if the transitional provisions contained this can be done just in the same item, where we should put, in case the the body which is going to carry out the procedure of assessment comes to a conclusion that a judge who was nominated to the position of judge for the first time, if he successfully passes this kind of examination or assessment at the level which is now specified by the people of Ukraine. So our proposal is that the same agency or the body, if they arrive at this conclusion, should address the President of Ukraine with a proposal to appoint such judges to their position for their lifetime. As I mentioned before, in our opinion, such an approach would be both fair and also will completely take into consideration the recommendations given by the European institutions, which have been almost completely taken into consideration by the Constitution Committee when they were they were working on preparing this draft document. Also, I would like to say that almost all the judges who fall under this problem to become the judges, they actually went through almost the same or at least similar competition procedure, which is now being proposed as which can actually reveal the capability of them to be judges. As you remember, the law in Ukraine on the right to the judge, to the fair court or the just court, the competition procedure has been already outlined pertaining to the nomination of judges. So the judges who actually have this problem, they went through the same procedure. Actually, they confirmed they demonstrated their capability to be judges, with one exception. We are talking a special period of training at the National School of Judges of Ukraine. But if you read attentively one of the articles in this law, which regulates the issue of this training period, it says that we have to check the capability of a judge to take care of the justice. And now, if we're talking about the judges who are appointed for the first time as a judge, and if they do their job, and there are no disciplinary claims toward this judge, if he or she does not violate the law, we believe that those judges should remain in their offices, and we should be given the chance to continue to performance of their duties. Just to add a few words, this problem is true for about 2,000 judges who have been elected only for the 5-year period of time. In the Constitution Commission, they can discuss this problem, but it hasn't been resolved within the constitutional procedure. We are talking about some kind of transitional provisions. They have to terminate their office, but they can actually claim to be reinstituted in their position according to the existing law. What does it mean? That the destiny or the fate of those judges will be resolved by the law later, beyond the limits of the constitutional procedure. In other words, nobody knows what will happen to them late in the future. There is no answer to this question, and this creates some kind of indetermination. Nobody knows what is going to happen to those judges, which runs counter to the international standards, which prohibit to have any discrimination about the judges who've been elected for their life term and the judges who were actually nominated as judges for the first time. There are a lot of questions of the President of Ukraine. The constitutional procedure is not over yet, and again, we are talking about the draft, the nationalization. This is from the vocabulary of the President term, and I believe that those recommendations or those requests will be considered with much attention. Generally speaking, this is the component which is conventionally associated by the society with the problem of cleaning and renovation, or let's say, or updating the judicial core. We have to understand that the judicial reform doesn't only mean renovation or cleaning, but unfortunately, all those definitely fundamental changes which have been fixed in the draft amendments to constitution, they are dwarfed by the social sentiments that do away with everybody. Let's get rid of the judges, and sometimes there's artificial slogans. They outbalance the real essence of the reforms. Judicial authorities do realize their problems. We understand in the judicial authority, like in the legislative or executive powers, there are people who do not deserve this high title of the public servants, state servants. But don't we have the same cases in the cabinet of ministers or in the parliament or any other state agencies? So why, when we are talking about the let's say returning the confidence to the authorities, they mostly talking about judicial authority. Actually, honestly speaking, the confidence and trust to the judicial power is real low in the society. But we have to know, we have our vision how this kind of cleaning or renovation, this is not legal terminology, but something which of late the citizens of Ukraine got used to, how to implement this law. Are there any ways to do that? In our opinion, there are. Conventionally speaking, we can divide this process in two parts. Renewal, or that means renovation, new people at least, maybe new judicial system, but at least new people can come to the judicial authorities. We have several hundreds of vacancies to fill the vacancies of judges. According to the latest figures, at least 100 vacancies which can be filled or start to be filled even tomorrow. There are at least 250 judges who today, maybe they already, they were rather voted for their second for different reasons, and at least 250 applications for firing. So we, all in all, we have 500 vacancies. So 10% of the judicial corps are prepared for any kind of competition contents to be declared based on any procedures in the nearest future, literally speaking. In addition to that, if they are going to renew, at least create the conditions for the judges to submit their applications for to be dismissed, and even those, and there were some restrictions, and some of the judges who even submitted such applications, they took them back because it was not beneficial for them to be dismissed. But irrespective of how this issue is going to be resolved, the question principle is we have either to cancel that right, or if we are talking about those judges who would like to be dismissed, there will be hundreds of those judges who will not be, they will not agree to go through some kind of assessment, and they will prefer or choose to their right to retreat. In this way, we are going to have several hundreds, maybe thousands, of vacancies of judges. Vacancies which are not occupied by other judges, because I understand, because as soon as we start to fill those vacancies, the places of judges which are occupied today by the existing judges, everybody will try to defend their right to profession. And behind such a conventional vacancy, we have the court litigation, the court cases, which could be sometimes sent to the European courts, and any kind of attempts of the collective reloading of the system or rebooting of the system, or some collective moves can be perceived as those which could be introduced in Ukraine. So in this way, thus several hundred of new judges will come to the judicial authority. This is the process of renovation, renewal. This can start anytime now. We need some new contest procedure. We have something to change. You are talking about the requirements for the candidacy and one of the mandatory conditions in the National School of Judges. And this is something of principle. We can still remember some time we did not have some requirements, maybe for some, or if they cancel that strict requirement, we can start this procedure of renovation anytime, as I mentioned before. Now, some of judges do not work because they were not re-elected or some other reasons, and each field vacancy, we are talking about some jobs in the judicial sphere which allow us to improve these kind of services. Cleaning, this procedure is a more difficult issue. In the higher justice instance, there are hundreds of complaints which are of higher sensitivity because they're based on the events in the times of Maidan and the revolution of dignity. So the people justly ask why, despite the fact that more than 18 months have elapsed, those complaints or those claims have not been considered. The executives try to make, to find some to clarify the situation in different branches of power, and specifically we are talking about those who served to the unfair regime. They blocked the movement, this procedure, and those bodies renewed their operation only in June. And some of them even earlier. For example, in December last year, almost 1 year ago, and the higher judicial collegium started to work several months ago. But the society demands the as soon as possible or the speedy resolution of those or consideration of those claims and complaints, and they ask to consider those cases as soon as possible and to resolve them according to the existing law. It doesn't mean that we or the other representatives of Judicial Court are going to criticize the actions of our colleagues. No, because we don't believe this is a fair thing not to consider those things. And there is an impression that the existing authorities try to slow down this judicial reform and try to provide coverage or the cover to those who they do not want to become responsible. This is not true. The judicial authority is fed up, and is tired to wait until the resolution of those things. We understand without going through this stage, the judicial reform we were talking about, the cleaning of the judicial authority will not take place. This is procedure is let's say unavoidable, so it's better to go through that as soon as possible, not to create some negative consequences. And another element of cleaning is assessment.
The assessment is a well-known procedure. It has world-level standards, and those who are able to pass this assessment, they will remain in office. Those who won't pass it will be dismissed. We believe that proper application of this tool would allow the society to get that judiciary which it deserves, which it has been demanding for so long period of time. I believe that society won't stay aside of this procedure and would assist us in creating proper conditions for satisfaction of everybody's right for a fair trial. Андрей Уманец, интернет-портал «Экономические известия». Thank you very much for coming here with a big problem, lack of communication between community of judges and public at large. Between 2010 and 2012, I had been writing much about the problems of the judiciary system. And my comment to you, you should look realistically at some things. You do not have a press center of the judiciary system. And on Friday, I sent an appeal about those judges whose appointments stuck in the Verkhovna Rada, and I haven't received any response. That's why you should realize that you not have any mechanism in place able to establish communication. If you wish to establish communication with a society, you should you try to create conditions for journalists. I believe that you should act differently. You should go outside. You should create conditions for outreach. And I never saw a press conference of judges coming to the microphone and pointing out to the problem that there is a big number of judges whose appointments after first term have stuck in the Verkhovna Rada. I think you should do this. Unfortunately, many judges are not ready to go to broad public and say that there is a problem. I spoke to the judges in the commercial court, and I know that they are not ready to go to public to speak at the microphone. If you wish to discuss this issue, we can discuss this after today's press conference. We know your position from your articles, and we are very grateful to your objective perspective. Mikhailichenko, the day publication. Thank you, dear friends, for raising crucial issues for the sake of the entire society. But I would like to mention that any court panel should be created lawfully, and after the revolution, we received information that many courts in Ukraine were established as business entities, as commercial entities. So now my question to you is whether you are ready to reestablish the courts as the subjects of public law. Frankly speaking, I am not familiar with this problem which you mentioned. Maybe you mean to the courts or judiciary department. I don't know. Let us discuss this problem in more detail after the press briefing. I think this is a sensitive issue to which you point out. We should discuss it. Any further questions? Any specifying questions? Since there are no further specifying questions, let us finish our press conference. See you next time. Thank you. Dear colleagues, our working day is over. The